My name is Pilar Tintore. I'm a specialist in family law and right of children. The purpose of my presentation is to explain the main differences between the diverse economic regime for marriage that exists in Spain. We have to start from the premise that the Spanish civil law allows spouses to choose the system by which their marriage is governed. This freedom of choice would have to be reflected in a document called antenuptial settlement. In the absence of such antenuptial settlement or the ineffectiveness of the same, the Spanish Civil Code states that it will prevail the joint ownership of a set economic system. But this economic system is not the only one possible in Spain. And that is why we have to know all the different types of economic regime in our country. Thus, the Spanish Civil Code includes three types of economic regime: the joint ownership of asset regime, the separate ownership of asset regime, and the accrual or participation system. But we also should know that Spain is a plurilegislative state in which different legal systems coexist in certain territory called autonomous community, which regulate different economic regimes for marriage to the three already mentioned. Therefore, we should know them and take them into account. Once we know this, in Spain we have 9 autonomous communities and cities with its own laws. These are Aragon, Balearic Islands, Catalonia, Valencia Community, Extremadura, Ceuta, Navarra, Basque Country, and Galicia. All of them have their own economic systems, and consequently, to know each in an economic regime of this autonomous community, we should look to their internal laws. Having said this, I'm going to describe the main difference between the different economic regimes that exist in Spain according to these laws. According to the joint ownership of asset regime, when the spouses get married, a community is formed with all of the assets or benefits during the marriage. This is what we know as marital property. Within this kind of benefits, we find both the properties of the work of the spouses and the interest that those profits create, and even businesses formed during the marriage. Faced with this marital property, we find the shared assets, which are those that only belong to one of the partners. These gains can be obtained due to a former marriage or received to give or inheritance, as well as personal object and all the necessary material that any of the parts must need to work, etc. In this sense, the ownership, enjoyment, administration, and disposal of the marital property correspond to both spouses. In case of divorce, to settle the joint ownership, it is necessary to make an inventory in which both the assets and liabilities of the conjugal partnership shall be entered. The assets will be composed of all the marital properties when the dissolution of society ends. If one of the spouses had fraudulently sold any of the marital property, it should be indicated what the value would have had that right if it had been retained in the assets of the partnership. The liability will be composed of all the debt that the partnership have outstanding. There will also be included the amount of the value of shared assets when they have been consumed in the interest of the partnership, and it must be returned in cash to the spouse who contributed, and in general those which constitute a spouse's credits against the society. The asset will be used to solve the liability of the partnerships, and the excess will be divided equally between spouses. The result of this transaction may be positive or negative. If it is negative, each spouse will settle the debt with his or her shared assets. According to the separated ownership of asset regime, each spouse remains in his or her possession all that goods that her or she already had before marriage, as well as those obtained during the marriage. As each spouse owns these properties, he or she can act independently, enjoying, managing and disposing of them freely. The only obligation that both spouses have is to help support two burdens of marriage, and unless otherwise agreed, they do that proportionally to their economic resources. All the housework is considered to be a contribution to the marriage laws, and this entitles to recognize the spouse who works at home a compensation that will be judicially fixed when the separation regime of property is extinguished. This compensation exists to mitigate the exactitude of this absolute separation of assets. Once the dissolution of liquidation of the regime arrives, since no real common assets are created in this regime, because the spouses have the entitlement of their own assets, the only assets that will be distributed are those indivisibles commonly owned, and the full ownership could be awarded either a spouse of such property, compensating the other financially. If it is impossible to determine who owns it, it will be considered that this corresponds both by half, and this should be considered for settlement too. According to the accrual participation system, we should take into account that each spouse has the right to contribute in the profits that his or her spouse gets while this regime prevails, that is during the matrimony. This means that every asset belong exclusively to each of the spouse, and only the benefit of these assets must contribute to the marriage. Each spouse retains the administration, enjoyment, and complete disposition of property of the assets had before the marriage. As in the case of the separate ownership of asset regime, in this participation system, not a common pool of assets is created. So when the liquidation of the economic system begins, each of the spouses will determine the standing of the final equity assets obtaining during the term of marriage. Whichever spouse has obtained in greater increase will have to share her earnings with the other spouse. So far, I have explained how the three economic systems collected in the Spanish Civil Code work. And now I'm going to explain briefly the different regimes that the 9 autonomous communities with their own legislation have. In Aragon, it's governed an economic regime for marriage called spousal consortium. In this spousal consortium, a common heritage is created with the assets of both spouses and those granted by marriage. All of them form the majority of the family assets, alongside the shared assets of each spouse. In this sense, the law requires spouses to inform themselves of the management of common and shared patrimony, together with the economic performance of the business engaged. In the Balearic Islands, Catalonia and Valencia community, in the 3 autonomous communities, the separate ownership of asset regime is the one used, which I had already explained. As a distinctive feature, we can add that in Valencia, the separate ownership of asset regime is only applied of those matrimony from April 25, 2008, and for those married before that date, the regime of joint ownership shall be applied. In Extremadura and Ceuta, the so-called fuero de baile is applied, which is applied in certain municipalities of Extremadura and the autonomous city of Ceuta. All the assets transferred by the spouse marriage become common when the conjugal partnership is liquidated. Likewise, in the municipalities or a small territory that lie within the autonomous community of Extremadura, in which the fuero de baile is not applied, we will refer the common law and apply the rules of the joint ownership. In Navarra, the married partnership of conquest is the regime applied. This regime is limited to acquisition made for consideration during the marriage community. It is similar to the joint partnership of the Spanish Civil Code, and we must distinguish between the marital assets considered common and are called goods of conquest, and those considered shared assets establishing as goods of conquest. Those whose exclusive membership are not recorded. the disposition and administration of these goods will be for both spouses. In the Basque Country, the matrimonial regime in Vizcaya is the leasehold communication property. In this regime, public equality between the spouses will be made. All the real estate, whatever their original are, belonging either spouse, both, provided and purchased goods during marriage. And in Galicia, the joint ownership regime is used, which I have already talked about. Once we know the different economic regimes that exist in Spain, the question would be, how could we know what kind of economic regime for marriage we have to apply to the dissolution of the marriage, provided that no marriage contract exists? The answer is very simple. First, we must determine if the spouses have a common personal law at the time of the marriage. That means if both belong the same territory. For example, if both of them are Catalan, the legislation to be applied in this case is Catalan 1. And consequently, the economic regime for this marriage and its later dissolution will be the separate ownership of asset regime. In the absence of this common personal law, it can be used the personal law or habitual residence or of either chosen by both in an authentic document issued before the marriage. If we don't have this election, we will use the law of common residence immediately after the marriage. And if there is not that common habitual residence, at last we will use the law of the place of the marriage. Once we have determined which law is applicable to the dissolution of the marriage, we can know the economic regime for marriage. To sum up, we can say that there are laws, different economic regimes in the Spanish territory, that the joint ownership of asset and the separate ownership of asset regime are the most common ones. But the lack of information about the regime could lead to the incorrect liquidation or distribution of assets, with the damage that this mistake would entail for our customers. Thank you very much, and I hope my statement has been useful to understand better some of the Spanish domestic law in family matter.